appointed by John Adams in 1801 at the very tail end of the Adams administration, when Adams had just been defeated by Jefferson for the presidency. Adams was on a campaign to establish a number of judges in the federal courts that had Federalist sympathies, and he wanted to name a new Chief Justice and had some difficulty in making the appointment. Marshall was his Secretary of State, and the story is told, I don't know whether it's necessarily accurate, but the story is told that Marshall and Adams had a conversation. Marshall, in the capacity as his advisor, Secretary of State, proposed various candidates for the position, and Adams had objections to every one of them. And finally, there was a pause in the conversation, and Adams said, "I believe I shall nominate you." Marshall then did not say no. He's 46 years old at the time. He serves for 34 years. And by the time he leaves the office in 1835, the court has been transformed. The court has become a major force in American politics and law, where it was at the time when he first came on a distinctly marginal institution. I think his main objective was to build up the court's authority and the court's presence as a governing institution. I mean, he assumes control of an institution that hears comparatively few cases, that doesn't have its own building. The justices don't have their own offices. His colleagues and he meet from 6 to 8 weeks total in the year in Washington. They spend most of the rest of their time riding circuit, holding court around the country. They're each assigned to different circuits, geographic circuits, and it being the days of horse travel, they're very lengthy visits from one locality to another. They haven't had a lot of significant cases when Marshall assumes the Chief Justiceship. By the 1830s, they've decided cases in virtually every important area of American life, from state sovereignty issues to the constitutionality of the Bank of the United States, to slavery, to they just, you name it. If there's an issue, if there's a contested issue of politics in the United States in that interval, the Supreme Court has entertained it. So by the time Marshall dies, the Supreme Court is a formidable institution. It's taking contested issues, social and political issues, it's resolving them, and the resolutions are treated with great respect. So I would say, if I were to ask to reduce it to one sentence, he built up the court. In some ways, the court was poised to establish a more significant role in American life, because the nation was expanding, the territory was expanding, there were more issues that surfaced, and in some sense, somebody had to resolve them. They couldn't be wholly resolved by the political institutions. But whether had a different sort of personality and figure been Chief Justice for those 34 years, the court would have reached the stature that it did under Marshall. I'm inclined to doubt that. I think he was a relatively unique figure. In Marshall's day, there was no limit on oral arguments, and the justices lived together in Washington in a boarding house. They were all transients. They were all from other portions of the country. None was a resident of the District of Columbia. And they were only temporarily situated in Washington because the court's session was so short. So they decided cases by hearing them. There was no limit on the time limit of oral arguments. They would hear cases sometimes for days. They would recess from the oral arguments and go back to the boarding house and start discussing the cases informally. They would decide cases with votes, and then opinions would be assigned to a single justice that justice would not circulate his opinion to the remaining justices. That opinion would be called the opinion of the court, whether or not it had been subscribed to by all the justices, because the justices, if justices voted the other way in a disposition, they would remain silent for the most part. So you couldn't tell with many Marshall Court opinions whether the opinion was unanimous or a bare majority. Now, of course, today we have a much more formal process. We know every justice's vote. We have time limits on oral arguments. We have, the court has a docket which results in conferences. We have concurring and dissenting opinions. Marshall would have been astonished at the process, and he probably would have despaired of the ability of the current Chief Justice, his successor, to control things the way he was able to do so. One I'd really like to talk to him about would be Martin versus Hunter's lessee. That's a case where there's a land dispute in Virginia in which one claimant's title comes back to an English heir and the other is essentially a squatter. It's on western lands in Virginia, which is very common for people to hold title to those lands who were non-residents, and they were using the lands for speculative purposes, and so people would go out there and just sit on them, and then they'd claim title. So this is an ordinary title dispute. The difference is that one of the litigants in the case is a syndicate of which John Marshall himself is a member. This is the group whose title descends from the English heirs. So Marshall is obviously an interested party, and according to judicial ethics, he would need to recuse himself from the case, meaning that he can't sit either as a circuit judge as the case progresses its way up to the court or as a Supreme Court justice. So he does recuse himself. Well, the case goes to the Court of Appeals in Virginia, and the issue that is presented by the time it gets to the Court of Appeals is whether a Virginia so-called Escheat Act, that's a statute that confiscates the lands of alien enemies, and was very common for states to pass these acts after the Revolutionary War, whether that should prevail over a treaty. The Treaty of Paris that ended the Revolutionary War gave interests of English claimants to lands in America, basically gave them title to those claims. So the question is whether the Treaty of Paris, when it conflicts with the Virginia statute, which is to prevail. Well, the Virginia Court of Appeals has a strong interest in having the Virginia statute prevail, and they hold to that effect. Now, the way in which you challenge a decision of a state Supreme Court is to file a petition called a writ of error. You claim that the decision was basically unconstitutional and you seek to challenge it. And you have to actually get a process together. Well, the Marshall Syndicate had grave difficulties getting a case up to the court because the Virginia Court of Appeals quite deliberately refused to make a record of its decision, basically trying to prevent the case from being sent up on a writ of error because there wasn't enough record. So Marshall's syndicate has to cobble together some kind of writ of error. And they get Marshall involved in the process. And he drafts the petition himself. This is even though he's recused himself from the case. He presents it to Bushrod Washington, his colleague on the court, and Bushrod Washington approves it, and the case goes up to the Supreme Court, and the court reverses the Virginia Court of Appeals. Well, the petition is in Marshall's handwriting. Marshall has a very distinctive handwriting. If you compare his letters with the petition, it's obviously he's written the petition. So I'd like to ask him why he did that, and couldn't he have just dictated the petition to a lawyer to avoid? Well, he obviously doesn't think this is a particular conflict of interest. He's operating under a different set of ethical parameters. So I'd love to hear more about that. To use a term that he never would have used, a 20th century term. He's an activist. He believes that the Supreme Court of the United States has a duty, as he put it, to interpret the Constitution in ways that sometimes restricted the power of Congress or state legislatures, and that is an obligation under the Constitution of the judiciary to do. He could have taken what we would call today a more deferential stance. The court had a certain amount of discretion to decide whether a constitutional provision was really at stake when there'd been a congressional or state legislation. He could have backed off and deferred more. He did not. Because I think he felt very strongly that one thing the Constitution did was place limits on the power of other branches of government. It was designed for him, it was designed in some ways to protect the rights of individual citizens against legislative and executive restriction. And it was his role as a justice of the Supreme Court in some ways to enforce those rights against, if you will, against the state. It was a rhetorical speech. It was an effort on Jefferson's part to try to signal that even though he had been the first partisan presidential candidate in American history, remember in the Washington and Adams administration, there are no parties. The Federalists, they ended up calling themselves Federalists, but in the Washington administration, it's just one party. And Jefferson has been the spearhead of, if you will, political partisanship. I mean, he's run against the incumbent president because he claims that his faction, if you will, doesn't share the views. So, you know, he wins the election. It's a very close election, but he ends up winning. And so I think he perceives his first mandate as trying to defang perceptions that he is just a partisan figure. And so that's why he uses that particular rhetoric. But, you know, one of the very first things the Jefferson administration does in office is repeal the Judiciary Act that was intended to establish more courts and create more federal judges, and the very first thing they do is repeal that. So they were a partisan group. They were not Federalists. They were opposed to the Federalists in many respects, and that was a piece of rhetoric. Aaron Burr wasn't a particularly likable figure. He was very able, but quite unscrupulous, not candid, inordinately ambitious, and he'd been Jefferson's political rival. I mean, he was, but for the House of Representatives, Aaron Burr might well have been President of the United States in 1800. So there's no reason why Jefferson would have liked him or trusted him. And for Burr's part, you know, he was the sort of figure that would quite deliberately provoke Alexander Hamilton into a duel. Jefferson, of course, not only believes that Burr is guilty of treason. This all starts with an ill-fated effort on the part of Burr to launch an expedition to Latin America, apparently with the idea of setting up an auxiliary republic of some kind, but it doesn't work out. And so Burr ends up getting tried in a Richmond court, and Marshall ends up being the judge that's controlling the proceedings. And Jefferson is furious because he believes that Marshall's charges about Burr are much too lenient. My view of the Burr trial is that Marshall who himself is no friend of Burr's, that Marshall is relatively scrupulous, and that Jefferson is a deeply partisan figure from the beginning. He wants Burr to be convicted of treason. And he's furious that Marshall, in Jefferson's view, prevents that from happening. Burr did have some demagogic tendencies. And, you know, it's conceivable. And Burr's instinct was to be rebellious. He's an anti-establishment figure, whatever the establishment is. Some of the people that he surrounded himself with on this particular expedition were a group of rogues and lowlives. And so, you know, Jefferson's expressed opinion can sometimes be inflated, but I think there might have been something in that. He reacts by, let's say, encouraging a series of pamphlets that are issued anonymously under pseudonyms taken from classical names, written by Virginians, that attack the decision. That's one of the fascinating stories of the Marshall Court, because when these pamphlets appear, they're written by William Brockenbrough and Spencer Roane, who are both judicial figures in Virginia and associates of Jefferson. They may well have been read by Jefferson before they were published. They were published in newspapers that were sympathetic to the Jefferson Republicanism side of politics. And Marshall notices them and finds them troubling and decides that they need to be responded to. And so what he does is write some essays himself, which respond to the criticisms of McCulloch. There's another set of pamphlets involving the decision the Marshall Court made in Cohens versus Virginia. More pamphlets come out. Marshall writes the opinions anonymously, and he arranges for publication in newspapers that are sympathetic to the Federalists. And they're fascinating pieces on both sides. They're very learned critiques and defenses of the McCulloch case. And of course, he takes pains to write very elaborate rejoinders to the anonymous pamphlets attacking the court on McCulloch. But what happens is, the way he wants to get these published is to arrange with a sort of sympathetic publisher, and he uses Bushrod Washington as an intermediary. So he turns the essays over to Washington, who then gives them to the publisher, and they appear in serial form. So not the entire essays are published at once. Well, what happens in the process of their getting published is the newspaper publisher mixes up portions of the essays and publishes portions. Marshall has, let's say, 5 separate arguments in logical sequence, and the publisher mixes up the sequence so that argument 3 appears next to argument 1, and argument 5 appears next. And Marshall sees this, and they look like gibberish, and so he's very annoyed, and he arranges to have them corrected. All of this, of course, completely anonymously. These are essays that originally appear in the 1820s. It wasn't known until 170 years later that Marshall had actually written 2 of the major essays. Another set of critical essays emerges after the Cohens versus Virginia opinion. Jefferson is well aware of that, probably read them. Marshall believes, and writes someone to this effect, that the attack originates with Jefferson. Says that, you know, I believe I see the hand of the Grand Lama of the mountains in this activity. Jefferson, of course, at this time has retired. His presidency ends in in 1808, he goes back to Monticello and attempts to live the life of a farmer, but he's keenly spending time with politics, and the court is just a considerable source of antagonism for him for the remainder of his life. He's annoyed that the court is, as he calls, huddling up in a conclave and producing these opinions of the court. No one knows who wrote them or how many people have subscribed to him. So he wants to return to the practice of seriatim opinions, where each justice writes a separate opinion in the case. That's one thing he wants to do. He wants to he encourages his appointee William Johnson to dissent fairly frequently. He also proposes a method of constitutional interpretation, which is in a curious way a little bit like originalism. He thinks that when interpreting the Constitution, it's necessary to go back to the text of the Constitution and do no more than the text permits. He thinks there's been too much judicial glossing of provisions in the Constitution. So he would, if he'd had his way, it would have been a rather different Supreme Court. But of course there are some words, take the word commerce, or the word freedom of speech in the First Amendment, that are open-ended. And in those instances, Marshall will sometimes talk about the ordinary meaning of, what does commerce mean. He has to define commerce in a number of Commerce Clause cases, and he says, commerce is this, but it's more than this, and all men understand it to be that. It's a sort of appeal to the general sense of the community as to what words mean. The difficulty with the slave trade is that slaves, it starts with the proposition that slaves are property. So when slaves at sea on ships, and the ships are confiscated, then they're essentially the equivalent of cargo. And the law of slavery, as it emerges in the early 19th century, operates from those premises. So, with cases like the Antelope, you get what appears to be a sort of willful attempt on the part of judges to shut their eyes to the reality of the situation, that the people here that are being treated as one set of cargo are in fact human beings, and shouldn't they have opportunities to challenge their status? Marshall is no fan of the expansion of slavery. He's a member of the American Colonization Society. He would like to export freed slaves to Africa. Bushrod Washington is a member as well. And they're very strong proponents of this. Marshall believes, with many of his fellow founding generation, that slavery will die out as soil exhaustion makes tobacco crops inefficient, and so eventually it will just pass. But he is of a group that's committed, really, to a system of slavery. He has his own slaves. His contemporaries have slaves. Slavery is kind of a fact of life, if you will. Now, to be sure, it's limited usually to African Americans, and there's a lot of racism built into it. But those attitudes are also part of Marshall and his contemporaries' world. There are some other opinions of Marshall's involving Native Americans where Marshall essentially cements propositions that Indian titles have very limited existence, this sort of discovery and conquest theory of relationships between whites and Native Americans. But he also believes that the tribes have rights, and those rights should be acknowledged, by states like Georgia. So when states like Georgia summarily want to throw Indians out of the state or seize their land, Marshall is opposed to that. He and Story, Joseph Story, his colleague on the court, are in a group of educated Americans of their generation that are sympathetic to what they call the plight of Native Americans. They believe that Native Americans are very poorly adapted to the civilization that's going to emerge. They're going to become wards of the state. Their stories are kind of tragic, but they need to be represented, and they need to be respected. And so he's in a wing of justices on the court that are more sympathetic to the arguments that the Cherokee Nation advances in these two cases than some of the other justices.